They rolled out the banner, they dimmed the lights, promised Roman candles, election night. Said stand back folks, this one's huge, budget boom with a harbor view. They said historic, they said bold, said watch this city turn to gold. Drums were pounding, sparks would fly, thought we'd see that skyline cry. Oh, they sold it like Guy Fawkes on the waterfront, like thunder rolling down Lambton Key, like the sky would split above the beehive, a technicolor destiny. But we gotta use packet of sparklers, half damn, two bent in half, promised the scandal worth the fireworks, got a backyard birthday laugh. They hyped it like the harbor was burning, like the heavens would explode. Turns out it was clearance, then promises on a cautious council road. They said more points getting sorted, more point wastewater treatment plant and neon lights. We're fixing pipes for generations. Cue the patriotic bites. Three waters renewed, they cried. Historic songs, civic pride. 14 councilors standing tall, one mayor smiling. That's all your animals like a standing ovation. 14 and 1 in perfect sync on the budget for three waters renewal. You think the sky would blink, but we gotta use packet of sparklers, fizzing out in the breeze. Promise the festival of detonations, got polite applause and tease. They framed it like revolution, like the pipes would roar and glow. Instead it's duct tape optimism, moving carefully slow. They showed us glossy fly-through dreams, bike lanes shining in sunlit beams. Wellington City cycleways mapped in gold, safer streets, the story told. But somewhere between the hype and vote, between the headline and the note, the fuse got trimmed, the powder damp. Now it's sparklers at the camp. Light the fuse, count it down, 10, 9, shake the town. Ain't some, brace the blast, 6, 5, hold on fast, 4, 3, watch it glow, 2, yeah. Is that it? We wanted rockets over coordinate place, echoes across the bays. Instead we're squinting to fade little stars that fizzle in 30 seconds blaze. You sold us scandal level fireworks, city shaping budget breaking heights, but it's just 14 councilors. One learned some very responsible nights. Next time don't promise the harbor ablaze. If it's sparklers you plan to supply, we can handle a quiet reform. Just don't sell us a 4th of July. They rolled out the banner, they dimmed the light.
And good evening and welcome to tonight's Autopay podcast. Sorry, the repeat that was planned for today has been postponed to tomorrow because there's more live breaking news. And the reason why we've decided to sit there and do this now, I'll be honest with you, when you decide at about 3 o'clock this afternoon, based on a news report from RNZ of critical emergency, you can't exactly get hosts to sit down there and pull up out of the blue, and the other thing, so what has happened is, so last night in Parliament there was a bill run through Parliament called the Social Security's Accident Compensation and Calculations of Weekly Income Amendment Bill. It was read under a interim urgency, which means that the paper was able to sit there and do, and it basically, someone has gone and challenged the law. And the challenge in the law is effectively what's happened is that some people end up on ACC, or what they should be on ACC. They haven't actually been able to get onto ACC yet because of it takes longer to assess a claim, whether it's been accepted or not. So in the meantime, they'll apply for a job seekers benefit with medical diversion, which is effectively the old sickness benefit. Don't know why we still call it that. We haven't actually been calling it that for 13 years, but Paula Bennett made that change when she was the Minister of Social Development. But what typically tends to also happen is you can get also supplementary assistance such as accommodation supplement, winter energy payment, temporary additional support, disability allowance. And what's happened is with these supplementary supports is the fact that, so when you are paid, when your ACC is finally claimed and the payments are cross-credited and put back to where it would be, you have to reimburse working income and you have to pay that to ACC. Now, under the law, there's been a place that the base benefit has been in there. However, the supplementary assistance, which if you're on ACC, you might actually be entitled to that supplementary assistance depending on what your income is, especially if, say, your job was, say, a part-time worker at minimum wage and you're receiving 80% of that wage. That will probably make you entitled to supplementary assistance like the accommodation supplement or the disability allowance. And if you also have high costs like high rent, you would also be entitled to the, temporary additional support. So what's happened is someone's challenged it in court. Not surprised. Working income, really, they do a lot of things wrong. And this could have been prevented to getting this stage. But as usual with work and income, when you have something that is designed to be prevented to reaching that point, they will sit there and choose a decision that leads to, say, instead of it being dealt with at the Social Security's review panel, which is a step below the High Court, they go, yep, no, the law, we got it right, the law's wrong, let's sit there and do it, which contravenes the law. So then someone challenges the High Court, and then you get a High Court ruling that basically establishes the procedure of what is actually in there. So you have to actually stick with that procedure. The most famous case is Rooker, which allowed the fact that if you're in a domestic violence relationship, you're entitled to what would have been then the DPB, which is now the sole parent support, because Work and Income denied this person the DPB, or they charged them with benefit fraud that got overturned and got challenged in the High Court. And it's just one of those things of what happens. People challenge laws. They have the right to challenge laws. They have the right to challenge systems in there. And this is effectively, this bill, by the sounds of it, is circumventing that bill. So let's kick off with the first one. Now, just be aware, we're trialing a new feature that's on Restream, which allows to broadcast both in portrait mode and in landscape mode. So some channels will be watching in portrait mode, such as TikTok and one of our Facebook pages, and the others are watching there. So I will head on. So we're going to sit there and see. So let's kick off with the first part of how this all falls into place. So let's go ahead right now.
Podium will say aye. Aye. To the contrary, no. The ayes have it. I understand it is the intention of the government to introduce a bill.
Social Security Accident Compensation and Calculation of Weekly Income Amendment Bill introduction.
Point of order, the Honourable, Dr. Lawrence Zinan.
Thank you, Mr. Speaker. Sorry, I just, point of order, I seek leave of the House to correct our vote on the previous third reading of the Employment Relations Amendment Bill.
Leave has been sought for that purpose. Is there any objection? There appears to be no objection.
I would seek leave of the House to correct the Green Party vote on the third reading of the Employment Relations Amendment Bill from 15 to 14.
So it is, I think... Okay, that's been recorded. Okay, so where are we?
Okay.
Sorry, losing track here. The bill is set down for first reading immediately.
Mr. Speaker,
Honourable Louise Upson.
I present a legislative statement on the Social Security Accident Compensation and Calculation of Weekly Income Amendment Bill.
That legislative statement is published under the authority of the House and can be found on the Parliament website.
I move that the Social Security Accident Compensation and Calculation of Weekly Income Amendment Bill be now read for a first time. I nominate the Social Services and Community Select Committee to consider the bill, and at the appropriate time I intend to move that the bill be reported by the 26th of September 2026 and that the committee have authority to meet at any time while the House is sitting, except during oral questions, during any evening on a day which there has been a sitting of the House, on a Friday in a week in which there has been a sitting of the House, and outside the Wellington area, despite Standing Orders 193, 195 and 196.
Just for your clarification, did you say September or February?
Sorry, February the 26th?
Bingo.
My apologies, 26 February 2026.
Okay. The question... I'm sorry.
Mr. Speaker, the bill addresses judgments that the High Court has made that conflict with long-standing policy intent for how ACC compensation and income more broadly is treated in the welfare system. While these judgments highlight inconsistencies between legislation and long-standing policy, they do not reflect the principles of a targeted welfare system that provides assistance based on need, and they create inequities across ACC recipients in the welfare system. The financial and operational impacts of this High Court judgment are significant, and Cabinet has agreed to amend legislation to confirm the long-standing policy intent that underpins MSD's approach to charging income, including income from ACC. I acknowledge that retrospective legislation is not standard. However, Parliament is entitled to amend legislation in light of judicial decisions, and I consider it in the public interest for policy intent to be accurately reflected in the law. To be clear, the bill confirms long-standing policy intent and operational practice. It does not create new policy or change MSD's treatment of clients in any way. The first key change aligns legislation with long-standing policy and practice that income is charged against the period it best represents to ensure MSD charges a person's income accurately against their entitlement. Long-standing policy intends for MSD to charge income over a certain period, which is generally the period the person earned or became entitled to that income. When charging income for a past period, MSD may find that overpayments occurred and recoverable debt should be established. Mr. Speaker, charging income against the period it best represents has been a long-standing policy in the way income is treated in the welfare system. This core feature enables MSD to charge a person's income accurately against their entitlement by aligning it with the period it relates to. This is important as people can receive income that relates to different periods for many reasons. For example, a person may receive a large interest payment that reflects the past year of investment. In this case, charging the payment as a single lump sum when the person received the payments may not accurately reflect the period the interest best represents. In 2024, the Social Security Appeal Authority found MSD did not consider all of the relevant factors when exercising its discretion to determine the correct period to charge income. The bill addresses the Social Security Appeal Authority decision by amending the Social Security Act 2018. So when calculating a person's weekly income, including ACC income, MSD must determine the period the income relates to based only on the extent to which a person earned or became entitled to it in that period. If this is not possible, MSD must determine the appropriate period to charge that income having a regard to the period for which it was received, acquired, paid, provided or supplied. The key thing here is this change upholds a policy that's always been in place, to allocate income against the period it best represents, so that a person's income can continue to be charged accurately against their entitlement. Mr. Speaker, the second key change relates to the treatment of a person as a non-beneficiary when their ACC compensation payment reduces their benefit entitlement to zero for the past period. Currently, if a person's main benefit reduced to zero because of their income, long-standing policy intends for MSD to consider the person a non-beneficiary, which of course makes sense, and which may affect their entitlement to supplementary assistance. For example, non-beneficiaries are not entitled to the winter energy payment and are subject to income abatement for the accommodation supplement. This is unlike people with main beneficiary status who have a greater need for supplementary assistance due to their comparatively lower income. Mr. Speaker, assistance must be targeted to those who need it most in our welfare system. This policy reflects the principle that by ensuring people receive financial assistance relative to their income levels and are only receiving one form of income support for one need. In October 2025, the High Court found that MSD is operating outside of existing legislative authority when reassessing a person's entitlement to supplementary assistance after they receive a backdated ACC payment for a past period. This bill addresses the High Court decision by amending the Social Security Act 2018 so that when a person receives a backdated ACC payment, MSD must review specified supplementary assistance granted for that past period and treat the person as a non-beneficiary if their specified benefit reduced to zero. MSD may make changes to the person's entitlement as part of this review. This is an important amendment to ensure that when assessing a person's entitlement to supplementary assistance, MSD maintains equitable treatment between people receiving ACC payments at the time they earn it compared to payments earned for a past period, i.e. a backdating. Mr. Speaker, this bill introduces an amendment that has retrospective effect to ensure the policy intent is maintained for both past and prospective cases. Retrospective legislation isn't standard. However, it is an important public interest for this long-standing policy intent to be accurately reflected in the law and to mitigate any flow-on financial and operational impacts. This bill introduces a savings provision to ensure the key changes do not interfere with previous or ongoing litigation, reflecting the strong convention that parliamentary legislation should not generally interfere with specific cases that are before the courts. Mr. Speaker, there is some time constraints in passing this legislation so that we do uphold long-standing policy and practice to ensure that income is charged accurately against a person's entitlement, that ACC recipients continue to be treated equitably, and to mitigate the fiscal impacts to the Crown and operational impacts to MSD. Mr. Speaker, can I put my gratitude to the House on record for the engagement I've had with parties opposite in the interests of getting this bill progressed, and I commend this bill to the House.
The question is at the moment.
Okay, so you've sat down there and got the first summary part of what's been sat there and said there is that they are trying to effectively have tidy up after a ruling that has ruled what they're previously doing that they've been doing by convention by reassessment in the past. Now, I know what it's like to sit down there and get it. I had one situation where I had a debt wrongly created. It was only, I think, $13.50. But it took a threat of saying, I don't have the $5,000 to go to the High Court so you could do your job properly. And it, like, put it this way, I was forced to repay that debt before I was able to actually have it properly looked at and go, yeah, we got it wrong. Retrospective legislation. I can see MSD going above and beyond to create a debt. I have seen them create debts out of thin air and they go, but the debt's there, so it must be right. Please provide the breakdown for it. Trust us, I work for wins. Well, unfortunately, trust us, I work for wins doesn't sit there and stack it up. Because if you can't sit there and give me accurate information to show you how you come up to that debt, then trust me, I work for wins doesn't sit there and quite cut the mustard. So this is what coming out there. So hopefully we'll learn a bit more about how this legislation goes through as it goes through there. Because the annoying thing is, there is no Hansards available at the moment for us to actually read, and effectively it's just a straight, like, the annoying thing is the fact that, the bill was introduced yesterday, submissions open for the committee today, and we've got to have them in by Friday. This is definitely, rushed law to circumvent a High Court ruling. Okay, let's see what comes from the Labour Party.
Motion be agreed to.
Kia ora, Mr Chair.
The Honourable Willie Jackson.
Thank you, Mr Speaker. Can I first of all thank the Minister for looking at what should happen in terms of this bill over the next week or so, but very appreciative. And it's good sometimes that we can come up with a bipartisan approach, Minister. So thank you for the agreeing to a select committee process, which I think will be beneficial for everyone, given this kaupapa. It's an initiative that obviously when the courts are involved becomes very, very serious, and everyone's looking at us, and I suppose this type of process, if it had been rushed through, would not have been fair to many people, particularly beneficiaries. So the debate deserves more in terms of opportunity, and the select committee process will give us that opportunity. In terms of this court order, we certainly traversed it very closely as a caucus, Mr Speaker. And we believe that the court's ruling misinterprets the basic Social Security Act's long-standing policy intent that underpins MSD's approach to changing income, including income from ACC. The more you earn, the less support you get. That's the fundamental rule when spending dollars on welfare. This legal ruling could or does create a double-dipping process that isn't in the best interests of everyone. And as a decision that, Mr Speaker, that when we looked at it, we thought that if we were in government, we would be looking seriously at it also. Double-dipping between MSD and ACC, Mr Speaker, would undermine people's faith in the system, which is something we all need to avoid. So we're very pleased with this outcome, so we can traverse that and have people come forward giving their views. The financial and operational impact of these judgments are significant, Mr Speaker. Implementing them would carry significant costs for the welfare system through writing off or refunding debts, hiring a large number of staff needed to do this work, and dealing with the downstream impact on service levels. These are costs that have the added trouble of being seen to benefit some while benefiting others. The safeguard Labor has insisted on is that people won't get anything less than what they were and are entitled to based on their situation. So Labor's willing to be constructive over this, but we just don't want to run this through. We did not want to run this whole thing, this whole kaupapa through urgency over a few hours, and so we're pleased that the Minister has made some concessions here. Mr Speaker, Labor stands with those ACC claimants who took this case to court, and we respect their courage. But the view is that the way forward is not double-dipping in terms of the system. We'll endeavour to ensure that obviously there's a change of government, Mr Speaker, so those on welfare and ACC can see hope on benefits that ensure that they can thrive and not just survive, Mr Speaker. We need a welfare system that can focus on people's welfare, not just the cost to the state, but to enable that everyone has to see the system as fair. And if we allow this High Court ruling to stand, as much as it upsets people in terms of interfering in terms of court decisions, it can quickly create bigger inequalities. So the solution is not about double dipping. The solution is about treating people equitably and fairly, and also we have to look at our benefit system. We agree this High Court ruling would make things more unequal, Mr Speaker, and we want to keep faith in the system, but we also need to talk about lifting benefits as the solution here, Mr Speaker. The bill restores consistency across benefits, protects the sustainability of ACC and the welfare spending, and why there is quite a bit of support from our side is that it prevents inequities between recipients. So the reality is we need to go much further in supporting our beneficiaries on ACC, Mr Speaker, but we can't do that by creating more inequality. We look forward, Mr Speaker, to the select committee process over the next couple of weeks. Kia ora.
Well, Willie Jackson does have an interesting take on there, which is support. I'm nervous because he has sat there and said about support. So the devil will be in the detail on what's actually going to be done from that. We'll see what ends up coming out of the final picture of what's going to be in the bill. We're going to hear from Ricardo Mendes March, and I am very certain it's not going to quite be as rosy as Willie Jackson's approach.
Can I just begin by acknowledging Community Law Centre South Taroa, who actually, for the first time ever, acted as an intervener in the High Court case and won. I think Putting aside this issue and discourse that I've had about inequities and double dipping, let's make it really clear. We're talking about people who've had an accident, had an ACC claim in the system, and due to their circumstances, had to go on a benefit in order to make ends meet. We're talking about people whose rents or mortgage payments would have been so high comparable to the benefit that would have needed things like the accommodation supplement. We're talking about people who would have been struggling to pay their bills during winter and would have received the winter energy payment, which would have benefited them. There are people who've, as I said, suffered an accident, and we're having to navigate a complex, often broken ACC system to get the cover that they need. I know for a fact, having worked with community law centres and on the ground before being an MP, that these claims can take months, sometimes even years in some cases. And I want to acknowledge community law centres across the country who advocate for people to be able to get their legal entitlements from ACC and working income. And it's been a pleasure to have worked with the Waitamata Community Law Centre for several years and who hosted us at All Connection Against Poverty there, where we got to see the mahi that they do. So huge acknowledgement for what they do. Well, the Green Party finds itself in a tricky situation because we do not support this bill. I think on principle this is not necessarily about addressing double dipping. MSD already recoups the cost, well, basically MSD recoups the costs from ACC once somebody gets their ACC claim. That's the common practice. The High Court case was more about the supplementary assistance that they would have been receiving at the time. And I think as painting ACC claimants as though they would have been well off universally, I think it's just wrong. We're talking about people who would have potentially had a hard time while on a main benefit waiting for the claim. I think the solution here isn't so much to, once the High Court finds that MSD had effectively been acting unlawfully, to then go and say, okay, well, we'll just change the law so that it complies with the policy we've been unlawfully applying for quite a few years. I think the solution here is for the government to have a hard look at how they process ACC claims, about looking at the complexity of the systems, both welfare and ACC, that we've burdened people with, which makes those claims take ages, but also that people find themselves not being able to navigate those applications in the first place. I still find myself in the community with people not necessarily knowing what they're entitled to from ACC or from the welfare system altogether. And community law centres are at Aotearoa were right when they described the High Court case, and that the debts that currently we're being burdened unlawfully on people, which the government is about to basically legalise, could put people into duress and hardship because of the way that they either get taken as a lump sum away from their payment from ACC or as basically a reduction in the weekly income. I do not think that saying that this is about addressing inequities or double dipping is necessarily correct. And I think we're addressing the wrong systemic issue here. I'm concerned that when I don't see a legislative agenda from the government addressing the core issues that welfare recipients or ACC claimants face, that all of this does is take away a potential lifeline that could have been unlocked for people who would have been in hardship. Potentially even giving people who were well off the ability to pay that back could have been an option. Even just maybe setting an income threshold where if somebody does have the assets, in the same way we do in the welfare system, they would have had to pay that back. But I think I don't think many people would be accessing the benefit or, for example, the accommodation supplement if they were super well off. That's just not the case. So we're talking about people who often, as community law mentioned, were put into debts that increased hardship. So the Green Party isn't supporting this bill. I think, yeah, it's a bit between a rock and a hard place to kind of say that having a select committee process is better than just having it through urgency. I want to acknowledge that we deserve a proper select committee process nonetheless, but we look forward to adequately scrutinising this bill as much as we can during the select committee process that has been afforded. Finally, I just want to acknowledge everyone who suffered from an injury, an accident, or who's disabled and is trying to navigate a system that does not allow them to live with dignity. Ultimately, the Green Party is going to keep fighting for livable incomes and systemic solutions that actually serve our communities, as opposed to simply legalising something that the government had been wrongfully doing for decades.
So Ricardo has basically mentioned a bit about that the bill itself is, well, not the bill, but effectively MSD is known, for giving out the supplementary assistance, which is not subjected to the same scrutiny as the base benefit payments. But effectively, we have an idea where Ricardo says we understand why they are going against the bill. So, yeah, let's see what Todd Stevenson's got to say from ACT.
Todd Stevenson.
Thank you, Mr. Speaker. I rise on behalf of ACT to speak in support of the Social Security Accident Compensation and Calculation of Weekly Income Amendment Bill. ACT will be supporting this legislation. I think it's important just to again reiterate, New Zealand does look after its most vulnerable, whether that's people who have had an accident in the workplace or do find themselves needing help from MSD by being on a main benefit. This will not change. As the Minister outlined, there is no new policy in this bill that's going through the House tonight and then will go to our Select Committee for a truncated period. So there is no new policy. What MSD had been doing was long-standing practice under successive governments. And again, as the Minister said, it really was trying to make sure that the charging of income, including from ACC, was done in the period it best represented. And so, yes, we just need to get on with making sure that the policy, which has been clear for decades, is properly legally enforceable, and we will be commending this to the House. Thank you.
Well, that's just pretty much, I'd like to call it a sequel of speech that no substance, doesn't educate more of what's happening in there, but, you know, I'm not surprised with the fact that we've had it with such a tiny time given forward to actually be able to work out what is actually on plan for that. Let's see now, who is Dr. David Wilson from New Zealand First.
Dr. David Wilson.
I rise on behalf of New Zealand First as the ACC spokesperson in support of the Social Security Accident Compensation Calculation of Weekly Income Amendment Bill. We think it ticks a number of boxes for us. It's a pragmatic response to something that just is out of whack with what we're trying to deal with here. It's proving fairness and equality before the law, so it's improving that, and so we're very pleased with that. We understand that the Minister has got some pretty pressing things in terms of dealing with retrospectivity and time constraints with the legal process that's underway, so that where we're judging things like how income relates to welfare entitlement and that assistance is relevant to income level should be relatively easy, but there may be some unintended consequences in here that we don't know about, as may be suggested by the opposition. We would hope to believe that we look forward to the Select Committee process that will cover off any of those unintended consequences and lead us as a House to be unanimous behind this bill. Mr Speaker, we support this bill and commend it to the House.
Well, I'm not sure if we're going to get to unanimousness on there. So I do have here, we do have a copy of what the bill does say. So it's plans to insert a new clause into it, which is, it says, when the section applies only if MSD is satisfied that a beneficiary has received a payment of an instalment of a specified benefit in a period under the section of 2521, was it A of the ACC Compensation Act of 2001. Beneficiaries have later established a claim to an entitlement from the Accident Compensation Corporation in respect to all or part of the same period under section 2521-B of the Act, and all payments of the instalment as an excessive benefit payment under section 252-2, 3 and 5 of the Act, and is refunded or is required to be refunded under section 252-4 of the Act, and the beneficiary has received one or more payments of a specified supplementary assistance in respect to the same period under the Act. Number 2 sits there and says MSD must assess the following: whether the beneficiary was entitled to receive the specific supplementary assistance that was paid to them, whether the beneficiary was entitled to receive the rate of supplementary assistance that was paid to them. This is where I think MSD are going to balls things up. Under section, 3, MSD must assess those matters in review under section 304 if MSD is satisfied because of the review that the section applies, or in any other case in a review under section 304 that the paragraph requires MSD to carry out if MSD is satisfied in that section, if the section applies. In assessing those matters, MSD and the appeal authority, which is usually the place that the initial place of where appeals go to, or a court, on an appeal against MSD, was a decision made by MSD, must take the beneficiary not to have entitled to those instalments of a specific period and have not received the instalments of the specified benefit, meaning that the supplementary of the specified supplementary section under section 5. In this section, specified supplementary assistance means all or any of the following assistance: accommodation supplement, winter energy payment, disability allowance under subpart 4 of part 2, whether it is disability allowance under section 85 or special disability allowance under section 89, temporary additional support, a special benefit continued under section 23 of the Social Security's Working for Family Amendment Act 2004, as the section saved by Clause 19 of Schedule 1 of the Act. Specific assistance under the Temporary GST Assistance Program. Now, this dates back to 2010. Approved or established sections 1241-D of the Pacific Social Securities Act of 1964 on the specifics on the 27th of August 2010 and saved by Clause 21 of Schedule 1 of the Act as if it was approved and established under the Section 101 of the Act. And it is to insert 198A 3-A after Section 304 insert or 310B. God, that is a bunch of technical jargon. But yes, I think you gather what is being said on there. Now, let's hear from the Chair of the Social Services Select Committee, Joseph Mooney.
I think our colleagues are not here, so the next call, I understand, is a national protocol.
Thank you, Mr. Speaker. I rise to make a short contribution on the Social Security Accident Compensation and Calculation of Weekly Income Amendment Bill. In support of this bill, Mr. Speaker, this bill will amend the Social Security Act to confirm long-standing policy intent underpinning the Ministry of Social Development's practice relating to backdated Accident Compensation Corporation payments and charging income against past periods. This follows a High Court decision on the 14th of October 2025. The MSD was not operating in accordance with current legislative provisions relating to charging backdated ACC payments against past periods. Mr. Speaker, I look forward to the Select Committee examining this bill and reporting it back to the House, and we'll no doubt have more to say in the future on that. With that, Mr. Speaker, I commend this bill to the House.
Givealittle Page.
God, that just... I don't know how to sit there and say about that speech. That just didn't really educate me apart from that, but look forward to doing the Select Committee hearing. But maybe our viewers and those who are concerned, maybe do an oral submission. And Joseph Mooney can look forward to meeting you in the submission. You can also sit there and do that in person if you're based in Wellington or want to travel to Wellington, or you can always do it by remote via Zoom. So let's kick off with Camilla Bellich.
Thank you, Mr. Speaker. Good to have an opportunity to take a call on this bill. This is, I think this is a tricky bill for the House in the sense that there are a few aspects of it which deal with very vulnerable people, so people who have been injured, who are obviously on such low incomes before their ACC is approved that they are entitled to supplementary support from MSD. And looking through those things, that's things like the winter energy payment, its accommodation supplement, its disability support payments, and some transitional payments. So these are payments that obviously people need at the time. They're not payments that are probably enriching people at all. They're just payments so they can live their lives. And it is regretful that we have an ACC system which sometimes means that the difficulty in obtaining coverage when you should be entitled to it can mean a significant delay. And so we are looking at a situation where people will be finally receiving ACC, but of course will then have possibly a debt, and I understand from officials that either it can be a debt or taken off their ACC in terms of treating it this way. So this is something that we looked at as a caucus in detail, as has already been said. I think a thing that was really key for us was because this is something that obviously we're aware of the judgment, but the addressing of it, we were concerned there might be some people who would be adversely affected by this in terms of especially potential claimants who haven't put claims in, who would be excluded from the savings clause, which we do support. The savings clauses, I think, are very appropriate for those people who did work with community law, who did take that case, so they will be able to not be impacted by this bill, and also other people that have filed proceedings. So that is, we're very supportive of that savings clause. But of course, other people will be impacted by this. And it was helpful to think, well, would this mean that there would be people who would receive so little from ACC but potentially go into debt because of the nature of their MSD payments compared with ACC? And I'm not aware of any of those, but it would be, I think what's really helpful about the agreement to have a select committee process now is that gives people the opportunity to, if those people are in that situation, for that to be raised and possibly addressed at the select committee process. So I think this is tricky. There is an element of retrospectivity in it for the people who are not covered by the savings clause. I understand the policy rationale for that because of, and comments have been made about this by the Minister and by the Honourable Willie Dixon around having consistency, and I think probably for MSD it was maybe a surprise to have this judgment which went against the policy intent. So understand all of that, but I think it's really great to, even though it is going to be a shorter select committee process, for us to be able to just take a breath and make sure that what's intended from this bill and what we've been told will occur is consistent with the feedback that we receive from the public. So I thank the Minister for agreeing to have a shortened select committee process on this, and I do encourage those people who might be affected, community law, other people who work with beneficiaries and ACC to, if they can, even if they just make an oral submission or put one line in and talk to the committee, please try and engage with the committee. I think the intention here is to try and come up with a workable solution to make sure that there's fairness within the system. As Ricardo Menendez-March said, we need to remember these are not people who have asked to be in this situation. They haven't asked to be injured. They haven't asked to be so poor as to require MSD support. These are vulnerable people in difficult situations, and it's a tough thing to put people in debt like that. So it does. I think I can speak for other colleagues to say that anything that makes these people's lives more difficult is something that we don't do intentionally, and we take a breath and we're going to go through a select committee process. So we will be supporting this bill. I know colleagues on the Social Services Select Committee will do their best to try and make sure that this has gone through in detail, and just want to thank everyone around the House for their engagement on this, and I hope that those affected by this can use the Select Committee process to raise any issues that may not have been addressed in this first reading debate, and so we can progress, and hopefully the law that we come up with is going to meet everyone's concerns and have a just system. Thank you, Mr. Speaker.
Well, great you mentioning about the retrospectiveness there, Camilla. That is a big concern, is the retrospectiveness, considering one of the things that we've seen in the bill is the temporary GST payment that was paid out due to the changes into the GST system back in the 2010. And I mean, it was only $2 something a week, and it was just a temporary payment that went on for until the end of the financial year, and then on the 1st of April that disappeared when it was replaced with something a bit more superior. So let's see who's next up. Paulo Garcia.
Paulo Garcia.
Thank you, Mr. Speaker. I rise in support of the Social Security Accident Compensation and Calculation of Weekly Income Amendment Bill. The bill, Mr. Speaker, sets right an inequality arising from the situation where welfare entitlement and ACC payments coincide. In one situation, they're paid at the same time. In the other situation, ACC entitlements are paid ahead and followed by the welfare entitlement, which leads to the possibility that the second set of payments appear to have benefited the recipients more. That inequality is sought to be corrected, and the ability of the system to flow more freely and more effectively. I commend this bill to the House.
Now that speech sounds so tone deaf. You know, the reason why someone is having to apply for Social Security assistance while waiting for ACC is because that their claim is not being assessed in an adequate, timely manner, or their claim is complex. But you've just made it out that, people on ACC claims want to sit there and double dip. And it feels so insulting and tone deaf, because people want to do things once, do it right. And what you have just kind of sat there and implied in your speech was, they want to sit there and try and grab as much from every single different area, whether they're entitled to it or not. Choice of words mean something. And considering, yes, I know that you're not the minister, you did not sit there and put the bill under urgency, but if you're unsure on what you're going to say, sometimes it's better to say, I commend this bill to the House, and sit down and do a seat warmer speech, because you don't want that coming back at the election, back on what's happening on your statements there. Okay, next up, Helen White.
Helen White.
Thank you. I too found this a really tricky bill. It's just come to us, and I am on the Social Services Committee, and I look forward to a week of Select Committee, I think, that we've got coming, where we might be able to hear from some people who will be able to tell us their stories, and we'll get a context for this, and hopefully we'll end up with a better confidence in this, and perhaps even a better law, because Select Committees have been known to come up with some good amendments when required. So I wanted to just talk to what the bill's about at the beginning, because this is a bill where ACC has always been an incredibly important part of New Zealand society, and when you have an accident, you're going to get 80% of your earnings. It's a wonderful system, but there are situations where that hasn't happened because your ACC a claim has been declined. And I've had clients like that where I've taken their case through and they are often in a really difficult situation. They don't have much money because they've gone from being on a good income to being on no income at all. So MSD steps up and it offers assistance at that point, and it's offered a main benefit, and where necessary it's offered other benefits, supplementary benefits like the accommodation supplement and the winter energy payment. And when months and sometimes even years later there has been a decision to grant accident compensation because there in fact has been an accident or an injury, then the person has paid that back and the main benefit's been paid back automatically by arrangement. So that's come out of the payment, the lump sum that has come from ACC. And in this situation, there has been a recovery of the money that is the extra, the supplementary money that's come in from MSD. Now, some people will be on really good incomes. I've had airline pilots on ACC, etc. They actually will have a lot more money, and we would find it very hard to see them as vulnerable in the situation where they're being asked to pay back those amounts because they've got a big lump sum through ACC. But there'll be lots of people who have at a lower income, and it will be much harder for them to come and pay that money back that is being clawed back. So it's that group where the government's clawed back the money that the case actually it turns on those people. And we have a situation where what the government proposes to do is retroactive. It is stopping those claims now for people who have had money taken away unless they've put in a claim right now, as I understand it. So it is one that I take seriously. I think there is a vulnerable group involved, and I do think that we have a due diligence here to take this to a select committee. Yes, there may be issues where this is something that's valid, etc., but we should take it to the select committee and hear from the people most impacted. So I encourage people like community law and the people who've made claims to tell us these stories in that select committee process if they can, so that we have the full story. They are not necessarily going to miss out because of the savings clause, but they're probably the most likely to be aware of the consequences and be able to tell us the story of how this impacts on New Zealanders. So I think it's really great that we're going for this short period rather than going through this legislation tonight. And I will be on that select committee, eyes open, very interested in the most vulnerable who will be impacted by this, appreciating that it's a pragmatic piece of law in many ways, but I will be making sure that we do our job as the opposition to actually improve the law if necessary and to listen to the people impacted. Thank you for bringing this to the House and for taking it to Select Committee. I look forward to doing my work over the next few weeks. Thank you.
I'm not sure what to say there. I mean, yes, look forward to the Select Committee that can sit there and do it. The big thing is it's the retroactiveness, and it's also the fact MSD are known for going back and making retroactive mistakes, retroactive debts, poor explanation, as in not explain it, not giving breakdowns, and then obviously having to go through with the, having to fight them to repay it back. Because when you have a debt created out of the blue with no debt, you have a mandatory minimum payment of $10.50 per week. There is no exceptions to it. There's no leeway. And the reason why is that is because a debt that has been created over in advance, you don't have negotiation powers. So that does come out there, especially when, you haven't actually, you're not rolling in the dough. Okay, Rima Narkle.
Rima Narkle.
Thank you, Mr. Speaker. Mr. Speaker, I'm pleased to rise in support of this bill in its first reading, the Social Security Accident Compensation and Calculation of Weekly Income Amendment Bill. It is in its first reading, as we said. And Mr. Speaker, as I listened to the most of the speeches across the House tonight, starting with the Honourable Louise Upston, in a nutshell, what we're trying to do here is ensure fairness for everyone. And that's the purpose of what this kaupapa that we're beginning tonight. And indeed, Mr. Speaker, as we've heard, the bill aims to amend the Social Social Security Act 2018. And what we're trying to do here, as we heard from the Minister and other speakers, is that in essence, confirm long-standing policy intent underpinning the Ministry of Social Development's practice relating to, if we were to summarise, two situations: backdated accident compensation corporation, ACC payments, and charging income against past periods, Mr. Speaker. And the reason why we find ourselves in this situation is because of a High Court decision on the 14th of October last year, which held that MSD was actually not operating in accordance with current legislative provisions, and so on and so forth, as we heard, and it was extended, the reasoning by the Minister in the first speech of this reading. And so, Mr. Speaker, as I said, we find ourselves in these situations. And so the bill, as other times when we found ourselves in these situations, it aims to clarify the law in this situation on the impact of ACC payments on welfare entitlement and ensure the process, as I said, is fair for everyone. Under the current situation, as interpreted by the courts, those who receive lump sum payments are in a way treated more generously than others. And so, again, we want to make sure that there is fairness for everyone. We look forward to Select Committee, and I commend this bill to the House.
Well, I will be honest with you. I actually have liked the speech that you did, Rima. I'll be honest, it's not something I expected, but I do actually like the fact that, you know, you're literally talking about trying to be fair in the system. The way to make, the big thing that needs to also be worked out is like how to deal with supplementary assistances when we have these bills coming through. It's not something that's just straight easy. It's like, how do we deal with the deductions of it? How do we ensure that if someone is being deducted for supplementary assistance, they're not being deducted for the wrong supplementary assistance, something like that. I had a situation back in 2010 where I was receiving supplementary assistance, and because it was at the wrong figure, I had to pay that back. The same case manager, in my eyes, committed fraud because she also changed my start benefit date. It took about 28 days to process the application because of the time of year that it landed on. And she changed the start benefit date. Oh, well, it shouldn't have taken 28 days. So we're going to take 14 of those 28 days away off you, and we're going to sit there and bill it for you, while in turn removing my accommodation supplement to pay things off. She subsequently withheld accommodation supplement payments from me. So we've had, are we going to have that sort of situation? As I say, I consider this particular case manager committed fraud, and she was not held accountable for their actions. Now, that was back in 2010. Fortunately, I can't criminally charge her for that. There's a bill that passed Parliament called the Crime Theft by Employer Amendment Bill. I wonder if it could stretch to working income case managers who don't follow the law. Not sure. But besides the point, I wouldn't be, I probably can't go and prosecute her because it probably will be within the statutes and limitations. However, it just basically, we need to sit down there, get out submissions and make sure the concerns. There is concerns about MSD trying to make this work. Now, let's see what the next stage is from Tiano.
This government has a nerve to talk about personal responsibility, benefit dependency, and to talk about fairness when it is punishing the injured. It is punishing the poor, it is punishing whaikaha, the disabled, and it is punishing Māori once again. That's what this bill is promising, Mr. Speaker, if it passes in its current form today or without adequate time, full debate and transparent consultation. Allowing the bill to go to Select Committee for 1 week deserves no praise whatsoever, but a huge eye roll and a whoop-de-doo. Because if anything, it proves incompetence and inspires zero confidence in the current government. The bill overturns High Court findings, just as the member before me said, that MSD acted unlawfully. The nerve of the minister and its government to put itself once again above the law, above legal rulings handed direct from High Court judges across the country. It applies retrospectively, validating past decisions and creating, guess what, new debts. It's creating new debts. Māori, Mr Speaker, Māori are disproportionately affected due to the higher ACC claim rates, lower incomes and systemic delays. The Minister may purport that her bill prevents double payment, Mr Speaker, but be honest, if this bill is only about preventing double payment, why does it allow MSD to retrospectively reassess supplementary assistance that has nothing to do with weekly compensation? Can the Minister explain how validating past unlawful MSD decisions prevents double payment? Is the Minister aware that Ministry of Social Development already has mechanisms to prevent double payment? And if so, why is retrospective legislation needed, Mr Speaker? What evidence does the Minister have that existing systems for preventing double payments were sufficient, or insufficient, should I say, with regard to our whaikaha whānau, who have received no love under this Minister or her government? Whaikaha, our disabled peoples who will be directly affected by these changes, how does clawing back disability allowances, which is not a wage replacement payment, prevent double payment? On Māori equity and te tiriti, Mr Speaker, how does the Minister reconcile the claim of preventing double payment with the disproportionate impact this bill will have on Māori, who are overrepresented, as I said before, in both ACC claims and benefit receipt? On ACC delays and system failures, how does the Minister justify penalising people for ACC delays when those delays are caused by ACC and not the claimants? On retrospective lawmaking, Mr Speaker, why does preventing double payment require overriding High Court and appeal authority decisions that found MSD's practice unlawful? I mean, make it make sense, please. Where is the tiriti in the bill? Where is partnership? Where is protection? Where is equity? It's nowhere. It is not one line, there's no one safeguard, and not one whakaaro for tangata whenua, tangata tiriti, tangata moana, or any of the hardworking Māori, New Zealanders, Kiwi, and let's face it, we all know who the majority of this bill will impact. It's not just Māori, it's also injured workers, it's also our whaikaha, it's solo parents, it's low-income wages earners. It's the rural labourers in Tāmaki Makaurau, it's the builders, it's the scaffolders, it's the city labourers, it's the factory workers, it's the cleaners, it's the couriers, it's the forklift drivers, and it's the security guards. It's so many people, Mr Speaker, across our country, the increasingly brown engine room. Over 40% of Māori workers are in physically demanding jobs. That is who this is going to impact. Te Pāti Māori and myself as MP for Tāmaki Makaurau, we have spent more than 10 hours today deliberating on what impacts we can make and ensure that our whānau are protected going into this debate, into the discussions for Select Committee. We have created amendments and we intend to put them through this House and to have them deliberated by the House in all fairness. That is what we ask for, is fairness and to prioritise tangata whenua and tangata tiriti who are continuously pushed to the margins by this government and its Minister. We oppose this bill.
The question.
Now, something Detective Rogers has actually brought up here, which is quite interesting. If an employer, I'm pretty sure, overpays you, can't reclaim that income. Well, you certainly wouldn't be able to after 7 years. Now, I do know that when I worked for BP, we got caught with the annual leave problem of the accounting software miscalculating that. They went through the period of time that this dragged on to like 5 years after I left. And I mean, I still received, I received emails in 2022. I would have been out of there over 7 years. Hi there, you know, about annual leave claims that would have been dealt with on them. I mean, I'm glad I was out of there. But yeah, effectively, you know, like 7 years. Whereas MSD, what's written into that bill there, as some of you, Detective Rogers, just to put out there, takes into account to a supplementary system that dates back to 2010. You know, which is only $2 something per week. You know, it was a joke at the time, and so they're doing it. The thing is, MSD also does not have a history of writing off debts. Like, if you drop dead and you had life insurance to pay out, they'll chase your life insurance policy, they will chase your estate to get that debt, even if the debt hasn't been backed up with any claim whatsoever. You know, they don't like writing money off, whether the debt was rightfully or wrongfully established. So yeah, whereas the tax department's pretty much a little bit more generous on writing off debt, but I think that's because the tax department's a little bit more realistic on how they do things. So now there's a little bit argy-bargy that happens here. Let's see the argy-bargy.
Question is that the motion be agreed to. Those of that opinion will say aye. Aye. To the contrary, no. No. The ayes have it. Party vote has been called for. The clerk will conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes opposed.
Action New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
E whanga pōti whakahe.
Takata Ferris. Maramino Kapakingi.
1 vote opposed.
The ayes are 102, the noes are 20. The question is agreed to.
Compensation and Calculation of Weekly Income Amendment Bill. First reading.
The question is that the Social Security Accident Compensation and Calculation of Weekly Income Amendment Bill be considered by the Social Services and Community Committee. Those of that opinion will say aye. Aye. To the contrary, no. The ayes have it.
Mr Speaker, I move that the Social Security Accident Compensation and Calculation of Weekly Income Amendment Bill be reported to the House by the 26th of February 2026 and that the committee have authority to meet at any time while the House is sitting, except during oral questions, during an evening on a day which there has been a sitting of the House, on a Friday in a week in which there has been a sitting of the House, and outside the Wellington area despite Standing Orders 193, 195 and 196. Mr Speaker, I have said in my comments earlier it is really important that the long-standing policy intent of how ACC compensation and income more broadly is treated in the welfare system is consistent. It is important that the law is promptly clarified. It doesn't change any policy. There is nothing new in this policy. It is simply making sure that there is equity in the system, that it is fair, and if someone, for example, receives ACC on a weekly basis, as opposed to it being backdated, they might then be ineligible for some of the supplementary assistance. It's a very narrow scope, and that's the intention of what we're fixing here.
The question is that the motion be agreed to. Ricardo Mendes March.
Thank you so much, Mr Speaker. Speaking on this referral motion, I think it's, look, sure, 1 week is better than having it just go through urgency and having no opportunity to have the officials in front of us. But I do agree with the member from Te Pāti Māori who bluntly put it as sort of this is no great reprieve for those of us who are concerned about the impacts of this bill, and the fact that 1 week does not adequately allow us to unpack the reality that while members of the government may speak of this issue as to just continuing existing practice, the fact that a High Court ruling did find this existing practice unlawful. One of the things that I'm particularly concerned about the referral motion, which, again, while it will allow us to have a bit of select committee engagement, is that I don't believe the timeframe allows us to honour the contributions actually from other members of the House about the need to listen from communities affected. I don't think 1 week actually allows people who may have made or are making ACC claims adequately heard. People who have suffered accidents will not be adequately heard in a 1 week period. And so I'm concerned about the fact that despite the ability to scrutinise this piece of legislation outside of the debating chamber, that we will not actually be centering the voices of those most affected. I'm also concerned about the level of analysis that has been already produced by the government in relationship to this bill. I note that the government noted that a regulatory impact statement was not required for this bill. So we don't have that piece of information to further analyse who's more likely to be impacted in this 1 week period that the referral motion speaks to. And the 1 week period also, therefore, does not allow us to, for example, understand the makeup of people affected by this. What main benefit would they have been? What is the full breakdown of the supplementary assistance they would be receiving? And moving forward, what are the demographics that we're looking at? I just simply don't think a 1 week period will allow us to go into the level of detail that such significant challenge of ongoing policy by Community Law Centre Aotearoa, which was validated by the High Court, will allow us to have. So I think on the referral motion, I guess I just want to reiterate the fact that this does deserve adequate scrutiny. Sure, I don't think I would put it as generously as the first speaker from the Labour Party that this is a graceful concession from the government, but it is a concession we're happy to try and work with in the best interest of having some scrutiny in the Select Committee stage. And I highly encourage that if there is the opportunity in the Select Committee to hear from the public, that accommodations are made to ensure that we do it in as accessible way as possible. I certainly do look forward to listening in the 1 week period we're going to have from Community Law Centre Aotearoa, who, as I've said, we're breaking ground in the type of work that they do. But ultimately, I think there are people who, whether people like myself and my previous advocacy work on the ground, or even the Community Law Centre and the amazing work they do, they would have not reached. 1 week just simply does not cut it. So again, for us in the Greens, an ideal process, an ideal referral motion, would have allowed for adequate scrutiny of this bill as opposed to just a 1 week process. This is actually even shorter than I've seen other referral motions from other bills that have been touted as needing a certain level of urgency or prompt, action from government. Despite our, disagreements on it, I think I am concerned about this kind of way in which we say, well, it's not technically going through all stages of urgency, but then it is also not necessarily actually adding adequate scrutiny to the legislative process. So in terms of the referral motion, again, in the 1 week period, I'm also hoping that the government wisely, and I know the minister's also leader of the House, well, yeah, leader of the House, Thompson, so I think making sure that the process allows us to it's recess week next week, actually. So we'll have recess week to make sure we use the most of it. So I guess there's that. But even then on recess week, I hope that we can all use as much time as possible from it, acknowledging MPs will have to give up constituency meetings and other engagements to adequately scrutinise this bill. And also we are asking the public, if they are given the chance to submit, to effectively upheave their whole lives and or plans for the next 7 days or the next week to be able to participate in this process. And particularly noting that, if an accident would have prevented your ability to, say, type, write, or even speak, we are talking a very short period in which people could try to find an accessible way to contribute to this bill. Should the Select Committee actually afford public submissions? I've got a bad feeling that perhaps the 1 week period will mostly be used to engage with officials, and that is part of our concerns about the 1 week period, because I just simply can't think of a realistic way other than by invitation, for example, from Community Law Centre Aotearoa, that we'll be able to actually engage with the public on it. And even then, in the 1 week period, what I'm particularly concerned around is that if there are complex questions that arise from members of the opposition, particularly the two parties that are against it, it does take time for officials to sometimes come back with adequate information in relationship to our questions. So for example, if I was to ask within the 1 week period, hey, can you please give me a breakdown of the types of benefits that people would have been in while waiting for their ACC claims, I don't know if the officials will have that readily available for us in a 1 week period. These are the kind of important questions, Mr. Speaker, that a longer scrutiny period would have allowed us to ask, that I'm now afraid we'll not be able to adequately scrutinise. I appreciate being able to have at least the officials in front of us for some period, but and I hope that there is a good faith engagement from the Social Service and Community Select Committee around accommodating complex questions that may require officials to go back and do some analysis and further impact on equity issues. We've heard in the previous debate, Mr. Speaker, about how this was about equity, but then we have yet to see analysis showing us actually how we're achieving equity as part of this process. Without a regulatory impact statement, this 1 week referral motion goes back to being quite concerning. And again, I think, that having the two hypothetical options of having this introduced in urgency and then potentially having gone through all of the stages in urgency versus just 1 week does not sit fully comfortable with us. I highly doubt that anything will come out of Select Committee that will allow us to feel different, in our opinion, from a 1 week scrutiny of it. I think if the goal was to have full support from the House on the bill and the merits of the bill, better analysis should have been done that what this referral motion actually allows us to. And then other components that, for example, I have yet to see is whether a child impact assessment had been prepared. So, for example, this is something we could have asked the Select Committee process. I, again, doubt that the 1 week period will allow us to produce a child impact assessment, noting that, for example, some of the recipients who would have received a benefit may have had children, and those children and the well-being of the children and the debt that is accrued as a result of existing policy practice would have affected them. So in the referral motion, going back to it, does not necessarily allow us to go to that level. Another thing that I think could have also allowed us to do is to hear from other organisations who may have not been super deep into the High Court ruling, but who do advocacy around ACC claims, who could have helped us understand the actual length in which the ACC claims have, and, for example, some of the hardships that people may go through while they're on the main benefit around that, because it's not just about double dipping, as people have said. It's also about, for example, people may have gotten into debt while being on a benefit with a loan company, right? And those are the impacts of having been on below poverty level incomes while you're waiting for your claims to come. And I don't think other stakeholders or organizations may be given enough time to produce a good enough submission for an issue that I actually do think is really complex. I'm assuming that should the government had honored the High Court ruling, quite a few resources would have had to gone into honoring it. And this is the other thing that I'm worried that we may not fully understand from the 1 week referral motion, is that what would have been the costs to the government should the High Court ruling have been honoured. So while we accept the ability to have some level of scrutiny at the Select Committee, I also hope, Mr. Speaker, that yourself and your presiding officer teams in the next state of the debate can recognise the fact that most of the analysis and scrutiny of this bill will nonetheless still be held at the Committee of the Whole House stage, because I highly doubt we'll have the adequate amount of time in a 1 week period to scrutinise the bill that will allow us to come back to Committee of the Whole well prepared. Thank you.
Far out. Ricardo went on for that was sped up, but he went on for 10 minutes. It's just basically, good on him for sitting there making the point there. Now, Camilla has got more bits to sit there and say. Let's hear Camilla. God, this is going to be a lot of fun making these shorts coming out. Ooh, we're going to have a lot of footage.
Camilla Belch.
Thank you, Mr Speaker. I just rise on behalf of colleagues to take a single call on behalf of the Labour Party in relation to the referral motion. There's a TV programme, I think, on one of the networks at the moment called Nobody Wants This, and I think this is a situation, no one wants to be in this situation. I don't believe in that the government wants to be passing this legislation, and certainly we don't want people who are vulnerable, who've been injured, to be in a situation where they maybe thought that they were in a situation to not have to repay the debt and then to be repaying a debt. So it's not a bill that I don't think anyone wants to be debating necessarily. I agree with the 1 week select committee period, that it's obviously a very short time, but I suppose at the same time, I can't think of the number of times I've asked government ministers for bills in urgency to go to select committee, and so to have the government agree to that, I think should be mentioned and acknowledged, because I think obviously a lot of work goes into these programs, and I don't want to over-reg it, because I do agree that it's a short time, but I do think that at least having the select committee process will allow us to just look at the impact of the bill and make sure that it's achieving what we would like it to achieve. And I think members of the public may not be aware that often when these bills, especially when they relate to legal cases, come up, that we don't have a lot of time to assess whether there are pros and cons around them, or to do our job as thoroughly as we'd want to as legislators. So I do agree that it is a short time, but it's certainly a lot longer than the non-existent select committee that we may have had. So in all these things, it's about the balance of what we can try and achieve. I would say to the select committee, to thank them in advance for their work. I know this is a short turnaround period. I know that they will do their work diligently. Some things that I would suggest to them is, if there are people like organisations like Community Law, other organisations, they could be proactively invited to submit. They could be given the reassurance that they don't need to provide a full written submission to be heard. I think that's often a misconception when people write to select committees, that they feel they have to write an essay in order to have their say. The reality is, I think most members would agree, that mostly the things we remember are the stories people tell us at select committee. So if people have a story to tell and they wish to speak to the committee, I would encourage them to contact the clerk and to find a time to either do a written or oral submission in the way that suits them, because really that should be our focus, especially with the group of people that we're talking about, who will probably be surprised that they need to maybe do a select committee. There are other reasons why a select committee process is beneficial. I know there's been a Bora vet done on this. I haven't yet had time. I don't think it's on the table. I haven't had time to click through to the vet to read it. I think that the fact that we have a select committee process will allow us to analyse that properly, and there'll probably be, I would imagine that having a select committee process will probably, I don't know if it covers the select committee or the urgency or whatever, but I'm sure if anything it will be more favourably looked at than maybe when it was originally drafted. I also would hope that both ACC and MSD officials could make themselves available to that select committee, and that is because obviously this is an interrelationship between two types of payments, and ACC is a special type of payment and it is paid for by levies, and so there is an entitlement to that, and obviously MSD payments supported by taxpayers, and we have to make sure that we understand the interaction between those two payments as well. So we are supportive of the referral motion, because we want the opportunity for New Zealanders to be able to have their say in the committee. I totally accept the criticisms of those in the House in terms of the length of it, but I suppose we're pleased to have at least that opportunity to hear from people, to be able to understand, and I'm sure that that's what will happen, is that we will be able to more fully understand the bill as it has been explained to us and drafted, but grateful to the Minister for at least having this 1 week, and also for making the information available to us to inform our decision. It doesn't always happen, so it's good to be able to do that. So we will endeavour to participate in the select committee in good faith, thanks to those colleagues who will be doing that hard work, and I hope that people are able to feel heard in some way through this process in a situation, as I started with, which is not a situation that anyone wants to be in. Fixing a law that's inconsistent with policy is always difficult, and it sometimes happens in government. We understand that. It's not the thing that we want to be legislating on, but we understand why it's been brought to the House, and we are pleased to be able to support it to select committee stage.
And there's more on the lovely one. Lawrence Zunan has also got bits on there. Gee, it's taken a long time to have a motion put forward for the select committee.
Dr. Lawrence Zunan.
Mr. Speaker, I move that the motion be amended to delete 195 and meetings outside Wellington area during sittings. And the reason for me to move that motion is in twofold. The first thing is, as both of my colleagues, Ricardo Menendez-March and also Camilla Bellich, has addressed, is I would like to know from the Minister and potentially from the Chair, for the Chair of the Social Services and Communities Committee, on what is the expectation for a one-week select committee. This is really important because, if we're going to be doing this in 1 week, what are the resources that will be given to the select committee to be able to conduct the work most effectively, otherwise just 1 week for 1 week's sake. The reason I say that is, with 1 week being 26th of February, we are already a bit short on time, and that requires the report to be drafted as well. For those who are interested and are watching, normally a select committee stage is 6 months or 4 months at a minimum. Anything less than 4 months will require a referral motion and any subsequent referral motion debate on that particular motion. 4 months is pretty pressed for time, even at the best of times. But with 1 week, you're asking 1 week for the select committee to open submissions, for the select committee to hear from submitters, and for the select committee to be able to draft the bill, draft the report, amend the report, amend any changes that needs to be done to the legislation as amended version from select committee, and report back to the House. All of that needs to be done within 1 week. So I guess the question to the minister, should the minister would like to respond, is what is the minister hoping, and the chair of the select committee possibly hoping to achieve within 1 week? Hence, one of the first reasons for me to put in an amendment motion is the ability for the minister to actually respond to some of the queries that both myself, my colleagues Ricardo Menendez-March and Camilla Bellich has asked of the minister. And that, I think, is quite an elegant way for the minister to be able to respond. And as we all know, in terms of referral motion debate, you only get one shot at it, and the minister has already used her slot. But with this amendment paper, she's able to respond should she wish to. Now, going back in terms of the deadline as well, one of the things that we know is, for example, the select committee will take place tomorrow. Social Services and Communities Committee is a Wednesday committee. So it will be sitting tomorrow. However, as we know from Standing Orders 210, subpart 2, I guess, for select committees, you must have the agenda be available 2 p.m. of the previous day. So considering that we're already at Tuesday evening at 8:30 p.m., unless the committee agrees to it by leave of the committee, you can't alter the agenda to add new items, including hearing on this bill, in tomorrow's select committee. Which means that if the select committee doesn't give leave for that, they can't hear it tomorrow. I doubt we'll be able to hear it on Thursday because a lot of the people will also be in Thursday select committees. So that leaves Friday. And I guess that's one of the reasons why we have the exemption to Standing Orders 193, which allows meetings on Fridays, which does make sense. That can be something that is done. And then obviously next week. However, considering that it is possibly unlikely that the select committee will hear for tomorrow, or the select committee will be hearing on Thursday, I'm curious to know why the minister chose to exempt Standing Orders 195, which is meetings outside Wellington area during sitting. And that brings me to my amendment on why I think that should be deleted. Because Standing Orders 195 states that the committee may meet outside the Wellington area during a sitting of the House only with agreement of the business committee. But during a sitting of the House, unless we are sitting this Friday, which we aren't aware of, it won't happen tomorrow or Wednesday. Well, unless, again, something that's going to be happening next week. That's also a possibility. That's something that I didn't consider. Then, it could happen next Tuesday or Wednesday, true. But then the next question is whether the other standing orders that is exempted from this also makes sense when it comes to Standing Orders 196, meetings within the Wellington areas on a sitting day. That potentially also could happen. The select committee could ask submitters to come in either tomorrow afternoon or Thursday afternoon. Those two are also possibilities. I guess my question is, there's a lot of unanswered questions in terms of what is the expectation of a 1 week select committee. True, I agree with both of the previous members that 1 week is better than no week, that at least at the minimum you're able to ask officials some questions. But would officials be able to give us the response within 1 week, as my colleague Ricardo Menendez-March said? Because something like this with a 1 week select committee, this is not insignificant as a bill. The minister may say that we're actually not making changes, we're just codifying existing practice, but existing practice is not the same thing as existing legislation, which is what the High Court has ruled. And in this particular case, not only are we seeing that a bill being introduced that has a retrospective effect, which is usually a legislative no-no, and I'm sure that we'll be hearing a lot later on from the Regulations Review Committee on the fact that they're introducing a retrospective element during sort of a pseudo-urgency, I guess, with a 1 week select committee period. But it also doesn't allow those submissions and those sort of advice to be teased out. So I am interested to know what is expected to be done within 1 week. Again, this is a reasonably complex bill because it doesn't cover just simply social services, social development, or MSD, but it also covers ACC. So it would be good to see if there's an opportunity to actually bring in both departments in terms of the financial impact, because that's one of the reasons why we are looking at the retrospective aspect of this particular bill. How many people are actually affected by this? We know that there's a High Court ruling on this, but what's the exact number? What is the extent of the budgetary impact or financial impact to MSD? And if we're going to be doing a one-week select committee, why bother then introducing a retrospective element? You could also have it for 4-month normal select committee period, even shorter, or even a 1-month select committee period, and still have a retrospective element. A retrospective urgency, a bill of this nature and urgency should be introduced as a good legislative practice when it's trying to stop something that is about to happen, rather than retrospectively changing something that has already happened, including a High Court ruling. So there are a lot of these unanswered questions around this bill and around the whole process. And I know that there have been other instances that we've seen in the past. I think the ACC amendment bill as part of the 2024 budget debate is another example of plugging a gap between what is accepted or understood as existing practice versus what is specified in a law. And there's a retrospective element in that as well. And with that, we did actually were given opportunities to tease that out a little bit further. So with that, I won't dwell on it, Mr. Speaker, but I think all of those are important questions. I'll be interested to hear if the Minister is willing to respond to both my amendment, but also some of the questions that we posed. But again, I fundamentally think a question both in terms of the Select Committee, but also the Minister is, what are we hoping to achieve within 1 week?
Okay, so just to note to members as well that when members are putting amendments, that those must be written down. Okay. Okay. The question is that the amendment in the name of Dr. Lawrence Nunn be agreed to. Those of that opinion will say aye. Aye. To the contrary, no. No. The noes have it. A party vote has been called for. The clerk will conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
4 votes in favour.
Tāku Te Whereas.
1 vote in favour.
Marimina Kapakingi.
1 vote in favour.
The ayes are 54 and the noes are 68. The question is not agreed to. The question is that the motion be agreed to. Those of that opinion will say aye. Aye. To the contrary, no. The ayes have it. I declare the House in committee for further consideration.
Okay, so we've got what's happening on there. I'm about to repost the link to put in a submission. So get out there, put in a submission, request an oral select committee meeting to sit there and do this and try and make it all work. If you've had a bad experience with retroactive debts, deductions, that sort of thing with MSD, or you've had issues where in the past where they've made unlawful decisions, this is get through there. I'm looking at putting a submission to say that the initial bill have a sunset clause and for it to go for a proper select committee process in good faith, similar to how the search and surveillance legislation happened under the John Key government. So that is that's my 2 cents to put in there. So thanks for tuning in for our special unplanned Order Paper podcast today. We'll be back on Sunday for our normal shows. Our repeat that normally would have been done on Wednesday will be done at 7 p.m. tomorrow night. Thanks for watching, and we'll see you all back on Sunday.
Thank you for watching the Order Paper, your express ticket to the New Zealand House of Representatives. Every episode, we unravel the complex world of legislation, debate, and democracy. From bills to select committees, we've got it all covered. From our team of political commentators who will dissect and explain what's happened so you can remain up to date on what's happened in the Aotearoa, New Zealand Parliament. To support our channel, you can become a Patreon member at patreon.com/itsinthaballot. The Order Paper podcast is brought to you